on the legislative branch, which is Article 1 in the Constitution, and the third lecture was on Article 2, the executive branch, and this is the fourth lecture on Article 3, the judiciary branch of government. And since the creation of the Constitution, Article 3, which created the Supreme Court, and the Supreme Court has handed down decisions that have shaped American history from civil rights to election issues to the power of business and government. The Supreme Court is known as the court of last resort. It has the final authority to interpret the constitutional questions as well as federal law, and to uphold or reverse decisions of lower courts. It's the final arbiter and protector of our most fundamental rights as set forth in the Constitution. Supreme Court justices have rendered decisions that were applauded at times, but are now seen as repugnant, such as when it permitted the internment of Japanese Americans during World War II. At other times, the court has made decisions that were reviled at the time, but are now seen as bastions of freedom and wisdom. Although the power of the judicial branch has grown tremendously over time, that is not the way the framers originally intended it. The framers of the Constitution spent far less time and far less debate over the judicial branch than on the other two branches of government. They never intended the judiciary to be a co-equal branch along with the executive and legislative branches. And so, although Article 3 stipulates a court that is called supreme, that hardly means that the judiciary would outrank the legislative and executive branches. Rather, the word supreme primarily addressed the hierarchy within the judiciary branch itself, placing America's highest court, the Supreme Court, above lower federal courts that might be created. The Supreme Court was only supreme over other federal courts. It was not supposed to be supreme over the legislative or executive branches. The Constitution's general structure hinted at a very modest role for the judiciary. And so the Constitution listed the judiciary as last among the three branches. It is Article 3, not Article 1 or 2. And so federal judges would have no say in the selection of the Chief Justice of the Supreme Court or of any other justices. The Constitution failed to guarantee the Supreme Court any role in the appointment of judges or in the removal of lower court judges. Now, Congress does have the right to impeach and remove judges, yet judges do not have the authority to get rid of congressmen. Article 3 left the size and shape of the Supreme Court up to Congress. And so Congress and not the court would have the upper hand in deciding how, when, and where justices would sit, what rules or procedures they should follow. And Congress also had many weapons to brandish against Supreme Court justices. For example, the legislature could decide to grant or to withhold judicial pay increases, or to fund or deny judicial perks and support staff. So you can see that the framers made the legislative branch much more powerful and gave it much more leverage over the judicial branch. And the Supreme Court was given relatively few constitutional tools to keep its members in line. Apart from its power to reverse or affirm lower court decisions, the Supreme Court has little inherent power to punish insubordinate deputies or to reward loyal ones. Most of the constitutional controversy that flared up in the nation's first dozen years never came before the Supreme Court. And so there were a number of controversial issues. For example, early on in American history, a national bank was created. Now, there's nothing in the Constitution that says the federal government may establish a national bank. But under Washington and Hamilton, a national bank was established. The Supreme Court had no role in deciding whether that was constitutional or not. When Washington declared America's neutrality in 1793, the Supreme Court did not weigh in on whether Washington had that right or not, because originally the Constitution did not give the Supreme Court the right of judicial review. And we'll get to that in a minute. Now, the Supreme Court is the only court that is established by the Constitution. All lower federal courts are established by Congress. And those lower federal courts include 94 U.S. district courts, as well as 13 appellate courts. So district courts and courts of appeal are created by Congress. The Supreme Court is the only court created by the Constitution. Now, unlike the other two branches of government, the Constitution does not specify qualifications for serving on the Supreme Court. Whereas a president has to be at least 35 years of age, a senator has to be 30 years of age, a member of the House of Representatives has to be 25 years of age. There's no minimum age to serve on the Supreme Court. There's no residency requirement. You don't even have to be a native-born U.S. citizen to be a Supreme Court justice. According to Article 3, judgeships would be formally open to all free men of merit. And I'm sure that implication was free white men of merit. And that would include naturalized citizens or people in the country who were not citizens. In fact, 3 of the first 10 Supreme Court justices were immigrants, although most of the early justices came from relatively privileged backgrounds. To date, 6 Supreme Court justices were foreign-born. The most recent was Felix Frankfurter, who served on the court from 1939 to 1962. He was a native of Vienna, Austria. The youngest associate justice ever appointed was Joseph Story, who was 32 years old when he joined the bench in 1811. Associate Justice Oliver Wendell Holmes Jr. served from 1902 to 1932. He retired at the age of 90, making him the oldest person ever to sit on the Supreme Court. One thing every justice who's served on the Supreme Court shares in common is that all were lawyers prior to joining the court, although that is not an absolute requirement. Leading justices such as John Marshall, Earl Warren, and Felix Frankfurter had no prior judicial experience, but all justices have been trained in the law. Although the greatest legal minds have served on the court, so have political cronies of presidents. And so when Richard Nixon nominated Harold Carswell to the Supreme Court in 1970, one senator remarked, quote, "Even if he is mediocre, there are lots of mediocre judges and people and lawyers. They're entitled to representation too, aren't they?" So that's a justification for having mediocre judges. The Constitution allowed the president and the Senate to consider political and ideological factors when selecting Supreme Court justices. Thus, every one of the 8 men who sat on the Supreme Court before 1796 had been a highly visible member of the Federalist Party. So the Supreme Court was politicized right from the beginning. After Washington's 2 terms in office, openly partisan competition heated up in federal judicial politics. John Adams, who followed Washington and who was also a member of the Federalist Party, he stuffed the court with fellow Federalists. And then Jefferson, when he became the 3rd president, he was a Democratic Republican. And so he appointed Democratic Republicans to the Supreme Court. Not until Republican President Abraham Lincoln named a Democrat, Stephen Field, did a president openly reach across party lines in nominating someone to the Supreme Court. And when Lincoln did that in 1863, the deepest ideological divide at that time was not between Republicans and Democrats, but between Unionists and secessionists. The justices of the Supreme Court are appointed by the president, and the Chief Justice is appointed by the president. But there's no requirement that the Chief Justice must be someone already serving on the Supreme Court. Those who serve on the Supreme Court who are not Chief Justices are called Associate Justices. Only 5 of the 17 Chief Justices have served as Associate Justices prior to becoming Chief Justice. So in the entire history of the United States, there have been 17 Chief Justices. And of the 17, 12 were appointed Chief Justice, even though they were not at the time serving on the Supreme Court. The last time this happened was when President Bush nominated John Roberts as the Chief Justice. When he did that, John Roberts was not serving on the Supreme Court. Nothing in the Constitution requires the Supreme Court to consist of 9 justices. In fact, there haven't always been 9 justices on the Supreme Court. The Constitution left it up to Congress to decide how many justices should sit on the Supreme Court. The Judiciary Act of 1789 set the number at 6. A Chief Justice and 5 Associate Justices. But that number has ranged from a low of 5 to a high of 10. There are actually 10 justices on the Supreme Court in 1863. After the Civil War, in 1869, the number of justices was settled at 9, and it's been 9 ever since. Although in 1936, Franklin D. Roosevelt tried but failed to increase the number of justices to 15. Now that has become an issue today because with the appointment of 3 Supreme Court justices by Trump, there has been the suggestion that if the Democrats would have won the Senate, that the Senate would have added new justices on the Supreme Court to offset the conservative majority on the court. But the Democrats do not have a majority in the Senate, and so at this point, it is a moot point. But it could come up again if the Democrats win the 2 seats in Georgia in that runoff election on June 5th. January 5th. Thank you. Okay, now Article 3, Section 1 states that the judicial power of the United States shall be vested in 1 Supreme Court, and in such inferior courts as Congress may from time to time ordain and establish. Thus, once again, the Supreme Court is the only court established by the Constitution. All lower and lower federal courts are established by Congress, which we saw the courts of appeals and the district courts. Now, federal district courts hear cases at the trial level. So in district courts, it is a trial when federal law is in question. If that verdict is appealed, it goes up to the U.S. Court of Appeals. And so the U.S. Court of Appeals is the first level of appeal. Final appeals are heard by the Supreme Court, and that is why it is known as the court of last resort. Now, Article 3, Section 1 holds that the justices of the Supreme Court shall hold their office during good behavior. That's an interesting term, good behavior. This means they serve for life, and that can only be ended by impeachment, by death, or by resignation. Now, why should Supreme Court justices serve for the rest of their lives? Well, the argument for this is to protect the justices from political interference. Critics argue that unelected judges serving for life should not have the power to overturn decisions made by elected officials. So they're saying that judges are not elected by the people. Congress is. So you're giving a body that is not elected by the people, the Supreme Court, the right to rule laws passed by people elected by the American people, passed by laws of Congress, unconstitutional, and that there's something wrong with that. Well, Hamilton argued that although the judiciary was unelected, by determining what is constitutional, the Supreme Court is the true guardian of the ultimate will of the American people. But even today, some believe that the federal judges should not serve for life, that they should serve for a fixed term rather than have unlimited lifetime tenure. Now, some people feel that way because you wouldn't want to have Supreme Court justices into their 90s or more serving on the court. That's one argument. The other argument is that it gives too much power to certain presidents who have the fortune of being able to nominate justices to the Supreme Court. So, for example, Trump, in his only term in office, was able to nominate 3 Supreme Court justices. Jimmy Carter, who served the same length of time as president as did Trump, Carter had no opportunity to nominate any judges to the Supreme Court. Now, I mentioned that one way to get a Supreme Court justice off the court is through impeachment. Congress has the right to impeach Supreme Court justices, just as it has the right to impeach presidents. It's the same process. Impeachment charges are brought up in the House of Representatives, and the Senate serves as the jury and decides whether to convict or not. In the entire history of the United States, only one Supreme Court justice has ever been impeached, and that is Samuel Chase in 1804. The House of Representatives voted to impeach Justice Chase. He was an outspoken figure who was accused of acting in a very partisan way during various court proceedings. However, the Senate acquitted him, and he remained on the bench. And he remained there until his death in 1811. But he was the only Supreme Court justice to be impeached. Article 3, Section 2 defines the jurisdiction of federal courts. And so we begin with the Supreme Court having original jurisdiction. This means there are certain instances where a case comes immediately to the Supreme Court. It does not work its way through the lower courts and through the appellate courts. So what are those examples of cases that come immediately to the Supreme Court? Well, cases that affect ambassadors, cases that have to do with maritime jurisdiction, controversies in which the United States itself is a party, or controversies between two or more states. And there is another instance where a controversy between a state and a citizen of another state, but the 11th Amendment overturned that. And so now a citizen of one state who sues another state, that case does not immediately go up to the Supreme Court. And if you want to know the reason for that, you have to tune in January when we look at the amendments. In all other cases, the Supreme Court has appellate jurisdiction. So in all other cases, the cases have to move up from the lower federal courts to the appeals court, and then up to the Supreme Court. Now, the Article 3, Section 3 defines treason. Treason is the only crime defined in the Constitution. And treason is defined as someone who either goes to war against the United States or gives aid or comfort to the enemy. Now, in England, treason charges had been used to punish criticism of the government. And so to avoid that abuse, the framers established the standard of elements for conviction. Conviction must be based on the testimony of at least two people who witnessed the same overt act, or upon confession in open court. Now, because of this high standard of proof, convictions of treason have been rare in US history. In 1794, there was what was called the Whiskey Rebellion. Farmers in Pennsylvania objected to the tax on whiskey, and they rose up in rebellion. That rebellion was suppressed, but those participants were pardoned, and so they were not convicted of treason. Southern combatants in the Civil War were also pardoned. And so in the entire history of the United States, only 9 Americans have been convicted of treason. Now, you might think of the Rosenberg case, but the Rosenbergs were not convicted of treason. They were convicted under a 1917 Espionage Act that made it illegal to convey unauthorized information on national defense. Now, earlier, I mentioned the power of judicial review. Judicial review, the power of courts to determine the validity of the legislative or the executive departments of the government. This means the right to strike down laws that the Supreme Court considers unconstitutional. That is the greatest power the Supreme Court possesses. But when the Constitution was written in 1787, the framers had no idea that the Supreme Court would wield this power. They intended the court's jurisdiction to extend only to cases involving piracies, treaties, and the collection of federal revenue. And so the court's greatest weapon, the right to declare laws unconstitutional, does not explicitly appear in the Constitution. The term judicial review is not included in the Constitution. Nevertheless, many of the drafters of the Constitution had implied that the Supreme Court should have the right to overrule laws passed by Congress, and that laws that it felt were in opposition to the Constitution. Federalists explained that judges could and should refuse to enforce federal laws that were, in the words of Alexander Hamilton, contrary to the manifest tenor of the Constitution. This is what Hamilton wrote in Federalist 78, that the judiciary must be empowered to strike down laws passed by Congress that the Supreme Court deems contrary to the manifest tenor of the Constitution. That was Hamilton's interpretation. Now, while the Constitution does not specifically empower the Supreme Court to review the constitutionality of laws, it does contain provisions upon which judicial authority can be based. And so Article 6, which we're going to look at in a little while, Article 6 states that the Constitution and the laws of the United States shall be the supreme law of the land. And although it did not appear so at the time, that clause gives the Supreme Court the power to declare any state or federal law unconstitutional if the court deems that they violate what is written in the Constitution. And so this is what is known as the Supremacy Clause. It is what makes the Supreme Court, in some ways, the supreme branch of government. The most ardent defender of judicial review was Alexander Hamilton, who argued that courts were designed to keep the legislature within constitutional limits. Now, the Supreme Court did eventually assert the power of judicial review. And between 1789 and 1850, the Supreme Court overturned more than 30 state laws, declaring those state laws unconstitutional. But in that period, from 1789 to 1850, the court only overturned a federal law one time. And that was in what is perhaps the most famous Supreme Court case of all, and a Supreme Court case that no one understands, Marbury versus Madison. Now, to understand this landmark case, we have to appreciate the political situation that existed in the United States in 1800. In 1800, John Adams was serving his last year as president. He was a Federalist. In November of 1800, he lost his effort for re-election to Thomas Jefferson, who was from the Democratic Republican Party. Now, John Adams lost the election in November, but he would not leave office until March of 1801. And in that time between the election and the inauguration of a new president, John Adams appointed John Marshall as the Chief Justice of the Supreme Court. And then in February of 1801, in February of 1801, a month before Jefferson would take office, the Federalist-controlled Congress passed the Judiciary Act of 1801, and they added 26 judges to the lower federal courts, all Federalists. So when you hear court packing goes back to the Judiciary Act of 1801. So here we have an outgoing Federalist president, an outgoing Federalist majority Congress, and so before the new Congress takes over, the outgoing Congress adds 26 judges to the federal courts, and all of them were Federalist judges. So this was a clear attempt by the Federalist Congress to pack the courts. Now, once the new judges were confirmed by the Senate, they still could not take office until the Secretary of State places his official seal and delivers commissions to these 26 judges. But because the Senate took so long to confirm these new judges, the large stack of commissions did not reach the Secretary of State's office until hours before the deadline of midnight, March 3rd. Now, by the way, if you find this confusing and you can't follow it, don't worry. What's important about the Marbury versus Madison decision is its significance. But I'll just give you the nuts and bolts of what happened. And so now, the incoming President Jefferson ordered his Secretary of State, James Madison, not to deliver the commissions to the newly appointed judges, because Jefferson did not want to see 26 new Federalist judges. One of those judges who had been appointed by the Judiciary Act of 1801 was William Marbury. And so, because Jefferson ordered Madison not to deliver the commissions, Marbury was not going to be able to serve as a federal judge. And so he took his claim to the Supreme Court. He petitioned for what is known as a writ of mandamus, which is a legal order that was provided for in the Judiciary Act of 1789 that compels the delivery of these commissions. And so the Supreme Court heard the case, and the case was known as Marbury versus Madison. Although the court found that Marbury was entitled to his commission, John Marshall, his Chief Justice, held that Article 3 of the Constitution did not give the Supreme Court original jurisdiction to issue writs of mandamus, and that therefore the Judiciary Act of 1789 was ruled unconstitutional. According to Article 3, original jurisdiction applied only to cases affecting ambassadors or, as we saw, maritime issues or other public ministers and councils. So essentially, what happens here is the Supreme Court rules that the Judiciary Act of 1789 was unconstitutional. That's the first time the court had exercised judicial review. And by extending the court's original jurisdiction to include cases like Marbury's, the court ruled that Congress had exceeded its authority. And when an act of Congress is in conflict with the Constitution, Marshall said, it is the obligation of the court to uphold the Constitution, because Article 6 says that the Supreme Court is the supreme, that the Constitution is the supreme law of the land. So what is the significance of all this? Why is this so important? Well, as you can see, Marbury versus Madison is arguably the most important case in Supreme Court history. It was the first instance in which the Supreme Court applied the principle of judicial review. In fact, you could argue that Marbury versus Madison made the Supreme Court more powerful than the other two branches of government. And more importantly, Marbury versus Madison is really the wellspring of our system of checks and balances. It's the way the Supreme Court could prevent the president from trying to exceed his powers, or Congress from trying to exceed their powers. But the question of whether the Supreme Court had the final say on the meaning of the Constitution, that would not be resolved for another 150 years. Both Jefferson and Madison, excuse me one second here, both Jefferson and Madison argued in the Virginia and Kentucky resolutions in 1798 that states could declare federal laws unconstitutional. In 1798, the Federalist Congress passed the Alien and Sedition Acts, which in essence made it a crime to criticize the President of the United States. Well, the Alien and Sedition Acts themselves were unconstitutional, but the Supreme Court was made up of Federalists, and they were not about to strike down a law passed by a Federalist Congress. And so Madison and Jefferson, who were Democratic Republicans, proposed the Virginia and Kentucky resolutions, which asserted that states could declare federal laws unconstitutional. Well, that was never adopted. But in 1861, Abraham Lincoln, in his first inaugural address, insisted that the Dred Scott decision, which claimed that slavery could be extended anywhere in the United States, Abraham Lincoln insisted that that decision did not settle the question of where there can be slavery in the United States. So in essence, Abraham Lincoln was saying that as president, he didn't feel he had to go along with the decision of the Supreme Court. The Supreme Court did not explicitly declare itself to be the final authority on the meaning of the Constitution until 1958, when it denied the governor of Arkansas the power to oppose the Brown versus Board of Ed decision to desegregate public schools. And in that case, Cooper versus Aaron in 1958, a unanimous court declared that the federal judiciary is supreme in the exposition of the law of the Constitution. So the question of whether the Supreme Court can determine whether laws are constitutional or not, that was not finally resolved until 1958. Now let us take a look at the early history of the Supreme Court. Of all the institutions of government, Americans have held the judiciary in highest regard. But the Supreme Court was not always so supreme. In fact, the highest court in the land had rather inglorious beginnings. The first session of the U.S. Supreme Court met on the morning of February 1st, 1790 in New York City. But it conducted no business because it lacked the quorum of 4 justices and because there were no cases to hear, even if a quorum had been present. The Supreme Court was held in such low esteem that the first Chief Justice of the Supreme Court, John Jay, resigned after serving just a few years in order to become governor of New York. So as far as John Jay was concerned, being governor of New York was much more prestigious than being Chief Justice of the Supreme Court. And then Alexander Hamilton was nominated to replace Jay as Chief Justice, and Hamilton said, no thanks. And then Washington nominated Patrick Henry, and Patrick Henry said no. Another justice, John Rutledge, resigned his seat on the first Supreme Court in order to become Chief Justice of the South Carolina Court of Common Pleas. So John Rutledge thought that it would be better to be Chief Justice of the South Carolina Court of Common Pleas than to be a justice on the Supreme Court. Only one of the original 6 justices appointed by Washington remained on the court through its first decade. When the capital of the United States was moved to Philadelphia in 1790, the court was completely overlooked, and so there was no chamber provided for it. When the permanent capital was established in Washington, D.C. in 1800, the justices met in a committee room in the basement of the House of Representatives. The 1789 Judiciary Act obligated Supreme Court justices to sit on federal circuit courts spread throughout the country. The idea was to bring federal judges closer to the people, but it was an incredible imposition given the difficulty of travel in the 18th century. One of the reasons John Jay gave for resigning as Chief Justice was that he had to travel to circuit courts 7 months of the year. So think about this. Supreme Court justices would have to get on their horses or get in a carriage and travel around to different circuit courts to decide on cases. It would not be until 1891 that Supreme Court justices would be relieved of the burden of riding these circuits. During its first decade, the Supreme Court decided relatively few cases. Now, remember in the first lecture, we spoke about the compromises that led to drawing up the Constitution. One of those compromises was the Three-Fifths Compromise. which stated that for every 5 slaves, they would count as 3 people for the purpose of taxation and representation. Well, that gave Southern slave states enormous power because it added to their representation in Congress. And as a result, 9 of the first 12 presidents were from the South, because the Three-Fifths Compromise also added electoral votes to the South. And because presidents nominate Supreme Court justices, that meant that Southerners dominated the Supreme Court. And that was the case up until the Civil War. By the time of the Dred Scott case, slave states, which represented just about 1/3 of the nation's free population, those slave states dominated the Supreme Court. And so when the Dred Scott decision was given that said that slaves were property, that they could not be citizens, 5 of the 8 justices on the Supreme Court were from the South. Now, the court was around for 150 years before it finally got a permanent home of its own. Starting in February 1801, the court began meeting in Washington, where it occupied various sites in the Capitol building for more than a century. After the British burned the Capitol in 1814, the court even met temporarily in private homes. In 1929, at the urging of Chief Justice William Howard Taft, Congress finally authorized $9.7 million to erect a building that the court could call its own. This marble structure has been in use since 1935. Today, the building features its own police force. It even has a gym on the top floor. And the basketball court on that gym is nicknamed the highest court in the land. Shooting hoops and lifting weights are banned while the court is in session, however. Now, how should the court interpret laws? How are unelected justices supposed to apply the law in a way that is consistent with democratic self-government? How did Supreme Court justices interpret law without making law? Well, Justice Oliver Wendell Holmes believed that judges should not second-guess laws enacted by Congress unless the Constitution clearly prohibited such action. And so Holmes's point of view is known as judicial restraint. And so judicial restraint argues that the courts should defer to the policy decisions of the legislative and executive branches. Supporters of judicial restraint believe that judges should decide cases based on what the framers intended and what Congress intended when the law was originally written, and that they should set their rulings based on precedents. So under this philosophy, judges were expected to show great deference to established laws and previous court decisions, that they should be slow to make drastic changes in public policy. And so judicial restraint is connected with the philosophy of originalism. Originalists, such as Justice Antonin Scalia and sitting Justice Clarence Thomas, they argue that too often judges read their own personal preference into the Constitution. Therefore, they claim that the Constitution should be interpreted based on what the framers intended in 1787. Advocates of judicial activism, on the other hand, believe that judges should play an important role in determining public policy, and that they should be less reluctant to overturn previous laws and precedent. So judicial activism argues that judges should take into account how social values and conditions may have changed since the time of the writing of the Constitution. Supporters of this principle believe that judges can and should make independent decisions when their interpretation of laws differs from that of the legislative and executive branches. And so judicial activists advocate a broad or loose interpretation of the text of the Constitution. They argue that the Constitution is a living document whose interpretation changes from one era to another in order to meet the needs of a changing society. Now, you might be tempted to associate judicial activism and judicial restraint with political labels by thinking of conservatives as more likely to support judicial restraint and liberals as tending towards judicial activism. Well, while that is true for the most part, that hasn't always been the case. And so, for example, during the Great Depression, conservative justices adopted a judicial activist approach in striking down many of Franklin D. Roosevelt's New Deal programs. Okay, so that covers Article 3 of the Constitution. But before turning to the remaining articles in the Constitution, I think it's important to point out that it has been the judicial branch of government that has preserved democracy in these waning days of the Trump administration. When the executive branch has tried to overturn a fair and democratic election, when a majority of Republicans in Congress have supported Trump's unfounded claims that there has been a fraudulent election, it was the courts at state and national levels that thwarted Trump's repeated attempts to reverse the decision of the American people. And repeatedly, judges, conservative as well as liberals, in fact, some who were Trump appointees, would not allow that to happen. Years from now, history will record that if not for the judiciary, democracy in America could very well have been destroyed by a vengeful president who could not accept the verdict of the American people. So that is my last word on the judiciary. Now let us turn to the remaining articles in the Constitution. Article 4 governs relationships among the states, requiring states to respect court decisions made in other states. There is someone whose microphone is alive. Would you please mute your mics? Because there's some sound that's coming through. Okay. So we're looking at Article 4. Section 1 is known as Full Faith and Credit Clause. It requires states to respect one another's civil laws and court rulings. So if a person loses a lawsuit in California, but then moves to Maryland, the Maryland court must enforce the California court judgment. Or if a New Jersey court orders alimony payments, and if the former husband then moves to Florida, the Florida courts must also force alimony payments. But states are allowed to make certain exceptions for public policy reasons if the laws of one state conflict with the laws of another state. And so until 2015, if one state recognized same-sex marriage, but the couple then moved to a state that had laws against same-sex marriage, the second state did not have to recognize the marriage as legal. But in 2015, the Supreme Court ruled marriage a fundamental right guaranteed by the Due Process and Equal Protection Clauses of the 14th Amendment. And so now all states have to recognize same-sex marriage. Section 2 is known as the Privileges and Immunities Clause. It prohibits states from discriminating against citizens from other states without justification. And so Alaska cannot limit jobs on oil pipelines only to Alaska citizens. but California can charge out-of-state students higher tuitions because local citizens pay taxes to support public universities. Section 2 also provides for extradition between states. Section 3 sets conditions for admitting new states into the Union. Section 4 guarantees that each state should have a Republican form of government with representative institutions, and that the federal government will protect states from invasion and insurrection. Article 5 outlines the process for amending the Constitution, which was a way to make the Constitution flexible, to adapt to changing conditions. And it made peaceful change possible, thereby avoiding bloody revolution. So there are two ways to propose a constitutional amendment, although one of these ways has never been used. Congress can propose an amendment with a 2/3 vote in each house, or 2/3 of the states can petition Congress to call for a constitutional convention. That has never happened. So of the 27 amendments to the Constitution, they have all been proposed by 2/3 vote in each house of Congress. Now, once the amendment is proposed, it must be ratified by 3/4 of the states. Now, Congress can set a time limit when the states must ratify a particular proposed amendment. And so when the Equal Rights Amendment was proposed in 1972, Congress imposed a 7-year deadline. The Equal Rights Amendment was approved by 35 states, but that was 3 short of the necessary 38 states to fulfill the 3/4 requirement. But since 1979, some states have rescinded approval of the Equal Rights Amendment, and 2 states have voted to approve it. But in any case, the time limit has expired. More than 11,000 amendments have been introduced into Congress since 1789. And of the 11,000, only 33 have won the necessary 2/3 vote to be submitted to the states for ratification. And of those 33, 27 have been ratified. Now let us take a look at the last 2 articles, Article 6 and Article 7. Article 6 declared that the Constitution shall be the supreme law of the land. This provision is known as the Supremacy Clause. It proclaims that the Constitution is the highest form of law in the American legal system. It also states that no religious test shall ever be required as qualification to any office or public trust under the United States. Article 7 states that the Constitution must be ratified by 9 states, as they existed in 1787. And so, before we conclude this presentation, I want to talk a little about the history of the Constitution itself. You might be surprised to know that the Constitution received relatively little attention until the 1820s. Few books or pamphlets about the Constitution appeared in the generation after 1789. 25 years would pass before the first textbook on the Constitution would appear. From 1789 to 1860, only 1 state required that the Constitution be taught in school. Let me repeat that. From 1789 to 1860, only 1 state required that the Constitution be taught in schools. And by the way, that state was California. A major reason for widespread ignorance and indifference had to do with the 50-year agreement made at the Constitutional Convention. The delegates agreed that the proceedings in Philadelphia in 1787 should remain secret for the next 50 years to ensure that all the delegates would be dead by the time the public knew what happened. Between 1787 and 1840, when Madison's notes were finally published, Americans knew little about the activities and intentions of the framers of the Constitution. And that might explain why the 50th anniversary of the Constitution in 1837 was not widely commemorated. In fact, the Constitution was not recognized as a national symbol until 1850. In the years leading up to the Civil War, the Constitution was the focus of attention in terms of the ambiguity surrounding it when it came to slavery and the issue of whether the Constitution was a product of the people or the product of the states. Now, when Southern states seceded in 1861, they said that the Constitution was a compact among states. And if the states can create a constitution, then states could leave the Union. But others said that the Constitution was an agreement among the people, not the states. And therefore, states did not have the right to leave the Union. And they point to the first three words in the Constitution, we the people. It doesn't say we the states. The 100th anniversary of the Constitution in 1887 also was met with little fanfare, in part because of interstate rivalry. For example, New York refused to celebrate the centennial because Philadelphia took so much credit for the Constitution. Now, unlike July 4th, a specific agreed upon date to celebrate, July 4th is clearly the date to celebrate the Declaration of Independence, but there was no agreement on what date to celebrate the Constitution. Should it be celebrated on May 14th, the date that the Constitutional Convention first opened? Should it be celebrated on September 17th, when the Constitution was finally signed? Or on December 7th, when the first state, Delaware, ratified the Constitution? Or on June 21st, when the ninth state ratified the Constitution? Or should it be celebrated on March 4th, the convening of the first Congress? It was not until 1917 that Constitution Day was set for September 17th. So September 17th every year is commemorated as Constitution Day. Now, interest in the Constitution was revived in the 1920s and 1930s because of anxiety over the possibility of a Bolshevik revolution in America and apprehension about the need to Americanize large numbers of immigrants. By 1923, 23 states required instruction on the Constitution. By 1931, 43 states required it. In 1933, the failure of the Weimar Constitution in Germany led to renewed appreciation for the durability of the US Constitution. And throughout the late 1920s and 1930s, specific radio broadcasts focused on the Constitution. In the second half of the 20th century, Americans expressed respect and even adulation for the Constitution, but they were not very familiar with the contents of the Constitution. So, for example, a 1947 Gallup poll asked 2,800 Americans, what is the Bill of Rights? More than 41% 41% did not know or had no answer. So what you see on the screen is actually wrong. It was 59% did not know anything about the Bill of Rights. 2 years later, another poll of 1,200 people, only 28% could correctly state any accurate information about the Bill of Rights. A 2017 poll revealed that 37% could not name a single right protected by the First Amendment. Only 1 in 4, 26%, can name all three branches of government. and only 1 in 3 Americans polled can name any branch of government. None, not even one. And so the US Constitution is very much like the Bible and the works of William Shakespeare. Everyone knows about it, everyone speaks well about it, but very few people read it. And this concludes this lecture series on what the framers got right and wrong about the US Constitution. But I want to underscore what some people say the framers got wrong about the Constitution. They argue that it's antiquated. It's an 18th century framework for government for what was then a largely agrarian nation with relatively few people. They point out that it failed to address the greatest problem of the age at that time, slavery. Women were never mentioned in the Constitution, nor were Blacks or Native Americans. The Constitution, critics argue, has failed to protect the most basic right of any democracy, the right to vote. Yes, the 15th Amendment says that all adult male citizens have the right to vote, but there have been numerous instances of voter suppression in American history that continues to this day, despite the Constitution. And critics point out that while Article 5 makes it possible to amend the Constitution, it is so difficult to amend the Constitution that we are stuck with the Electoral College because the amendment process makes it almost impossible to get 3/4 of the states to agree to get rid of the Electoral College. Now, some of you may be familiar with a Broadway play called What the Constitution Means to Me. It is now on Amazon Prime. And if you have Amazon Prime, I strongly recommend tuning in to this show, What the Constitution Means to Me. It is a single performer, Heidi Schreck, who talks about the benefits and the problems of the US Constitution. Now, again, somebody's microphone is on. I want to finish by pointing out that the United States Constitution is the oldest constitution in the world. And for the most part, it has worked pretty well. Now, next month, I will be giving a 4-week lecture on the amendments. We're going to look at the Bill of Rights in depth, as well as the rest of the amendments. And that is going to be on Thursdays in January. And Jerry, correct me if I'm wrong, but is that going to be at 1 o'clock?